morning. This, of course, is our first virtual version of the conference. And I want to thank our planners, moderators, panelists, and sponsors for staying with us as we pivoted from the traditional live event in New York City to this virtual one. You can read all about all of the moderators and panelists in the bio section of our materials, a link of which will appear throughout the day in the Zoom chat box. Each of them provided exceptional ideas for these sessions, and of course the time and energy to bring them to life. But those who contributed much additional time and expertise in this planning of the conference are Bruce Johnson of Davis Wright Tremaine and Amanda Shanor, our first moderator and assistant professor at the Wharton School of the University of Pennsylvania. And thank you to our sponsors, without which we could not produce this event and offer it to you free of cost. Our host firm, Patterson, Belknap, Webb & Tyler, and Ballard Spahr, Barron Healy, Harris Healy, Davis Wright Tremaine, and Charles Koch Institute. I hope you will stay with us all day. Please feel free to put questions into the Q&A box, which will send them directly to the moderator. Our moderators will try to get responses to as many of the questions as time allows. CLE credit is being provided by Patterson Belknap under New York and New Jersey rules. If you want CLE, you can find the forms on the same website page as the bios and materials.
I said, mute him, yeah.
Who are you talking to?
Now I want to introduce Floyd Abrams, the quintessential man who needs no introduction to this audience. Floyd is currently senior counsel at Cahill, Gordon, and Reindel, and among his many accomplishments is his role in the creation of the Floyd Abrams Institute for Freedom of Expression, housed within the Information Society Project of Yale Law School. This conference is but one of the Abrams Institute's many accomplishments, individual and ongoing programs since its founding in 2011. With that, I turn it over to Floyd. Floyd, if you could unmute your microphone. Floyd? Well, it may be that Floyd is having some technical difficulties unmuting his microphone, one of the pitfalls of doing virtual rather than live, since one never has to unmute Floyd when we are live. But if my folks at Patterson Belknap tell me that the entire first panel is ready to go, then I will turn it over instead to Amanda Shanor, and we will pick up with Floyd later. Patterson? Hi, Amanda.
Hi, everyone. Hi, Sandy. It's wonderful to be with you here this morning. Though I'm sorry we couldn't hear Floyd yet. I would love to hear Floyd. I also appreciate your comment that normally we don't have to unmute Floyd. You also normally don't have to unmute me.
Yeah, I mean, one of the things I'm learning about doing all these virtuals is it was a lot more fun to be able to hug my panelists in person and know that they are there and unmuted. Anyway, welcome to all of you. And with that, I really will turn it over to Amanda.
Terrific. Well, thank you all for joining us relatively early in the morning, especially for all of you who may be on the West Coast. As Sandy said, my name is Amanda Shanor. I'm an assistant professor at the University of Pennsylvania, where my research focuses on constitutional law and particularly the First Amendment. I also used to do Supreme Court advocacy at the American Civil Liberties Union. I'm delighted to be joined today by Robert Post, Beth Brinkmann, and Genevieve Lakier, all brilliant constitutional law and First Amendment experts, and some of my very favorite people as well. Today, on this first panel of the morning, we will be talking about the recent shift or shifts in the Supreme Court's commercial speech and closely related jurisprudence, where the law is, where it may be going, and if we have time, what we all think it ought to be. Given our new online medium, we are planning on diving right into the conversation. I will give each of our panelists a brief introduction. You can find more information about their illustrious careers in the conference materials. And then I'll give just say a few words on the topic of our opening panel, and then we'll go straight into the conversation without any opening presentations, which I hope will make for a really rich and thoughtful discussion. Okay, with no further ado, our illustrious panelists in very brief form. Beth Brinkmann is one of the nation's leading appellate litigators. Beth is currently the co-chair of the Appellate and Supreme Court Litigation Group at Covington and Burling. She previously served as the Deputy Assistant Attorney General in the U.S. Department of Justice Civil Division, where she oversaw the division's nationwide appellate litigation as the country's top appellate litigator. She also has practiced for more than 2 decades before the US Supreme Court, including as an assistant to the Solicitor General and in private practice. She has argued a remarkable 25 cases before the Supreme Court and regularly argues in appellate courts across the country. For also all of you Yale people out there, Beth is a wonderful and illustrious alumnus of the law school. Next, we have Genevieve Lakier. Genevieve is an assistant professor of law and the Herbert and Marjorie Freed teaching scholar at the University of Chicago Law School, where her research explores the connections between culture and law. She is currently engaged in a long-term project on the cultural history of the First Amendment, which is fascinating, and has written a range of great law review articles, among other things, one on Reed v. Town of Gilbert, which is in your CLA materials, as well as on First Amendment Lochnerism, which is forthcoming in the Chicago Law Review, and I would encourage you all to read. And of potential interest to some of you, I also had the opportunity to do a set of SCOTUS blog events with Genevieve on the Supreme Court's recent robocall case, which some of you may be monitoring about whether the ban on robocalls to cell phones violates the First Amendment. So I can tell you that Genevieve is super fun over Zoom as well. And last, but certainly not least, we have Robert Post, Sterling Professor of Law and former Dean of Yale Law School. Robert specializes in constitutional law and legal history with a particular emphasis on the First Amendment. That's what his bio says. Robert's like the fanciest, most awesomest First Amendment scholar. Okay, Robert has written and edited numerous books, including Citizens Divided on campaign finance reform, as well as Democracy, Expertise, Academic Freedom, a First Amendment jurisprudence for the modern state, which for First Amendment folks out there, if you haven't read it, I would really encourage you to. Robert has a list of publications longer than my arm, including a terrific article on the rights of publicity with Jennifer Rothman that's forthcoming in the Yale Law Journal. He's a member of ALI and a fellow of both the American Philosophical Society and American Academy of Arts and Sciences. And before joining the Academy, for those media lawyers out there, Robert was an associate at Williams & Connolly, where his primary client was the Washington Post. So that is our fabulous panel for this morning. A quick note on practicalities. You should see a Q&A button at the bottom of your screen. If you would like to ask a question or send a comment to the panelists, please click on that button and you will write to us, you'll write to me. We will not be monitoring the chat window, so please do write any questions you may have in the Q&A, and we'll reserve time at the end of the panel for your questions and discussion. And also for those of you seeking CLE credit, at some unknown point in this proceeding, I will read a strange code that you should take note of. Okay, so those are practicalities. As to substance, as the opening panel of this morning, as I said, we'll be talking about the recent shifts in the Supreme Court's framework for commercial speech law and speech and economic life more broadly, its recent trajectory and the ideas that animate it, and where potentially it may be going or its possible futures. A growing number of commentators, including all the academics on this panel, have argued that the Supreme Court has been, let's say, flirting with shifting its commercial speech and even broader First Amendment jurisprudence towards a one-size-fits-all speech is speech or anti-classificatory approach, suggesting perhaps that all speech should presumptively receive heightened scrutiny. At the same time, what counts as speech for First Amendment purposes, what the academic literature calls First Amendment coverage, seems to be expanding. So more things, think anything from a disclosure thing in your credit card statement to a cake, seems to be expanding such that more things seem to be understood culturally, potentially to be speech, threatening to transform the First Amendment into a powerful deregulatory engine and raising concerns of First Amendment Lackerism. In a series of cases, including many that you're likely familiar with, such as Reed, Sorrell, Janus, and Nifla, maybe Masterpiece Cake Shop, the court has issued broad, perhaps vague statements on basic First Amendment principles, raising troubling, maybe grave rule of law issues, and the specter of unelected judges striking down laws they dislike, but opportunistically preserving those that they favor. At the same time, I think we would be remiss not to note concerns that maybe expanding heightened scrutiny may at the same time dilute it. At a moment where we see, for instance, yesterday, the president tear gassing peaceful protesters, at a time where we may need the First Amendment in certain contexts and its robust scrutiny. There are these shifts, we wonder, have potentially enormous implications for other fields, really at the edge of what we traditionally think about as commercial speech for things like data privacy, intellectual property law, anti-discrimination law, all manner of things, disclosure regimes, even bread and butter economic regulation. So while normally this conference is focused on commercial speech, now really it's commercial speech is increasingly important, we might say, or what's happening within it to issues that are just on the edge of that with potentially large implications for the future. As your opening panel, our role is to explore these changes, offer any commentary we might be able to have, be able to offer, and consider what these shifts may portend for the future. So with that, I'm excited to begin our conversation. I'd like to kick it off by asking our panel where the Supreme Court's commercial speech, I'm going to say liberally conceived case law, was, is, and appears to be going. Robert, you've written really brilliant things describing this First Amendment case law and the ideas behind it. Could you lay out some of the court's mid-century understanding of the relationship between the First Amendment, both to commercial speech and commercial regulation?
Sure. Thank you, Amanda. Thank you, Sandy. And thank you, Floyd. I look forward to hearing your remarks. And thank you, my fellow panelists. You look wonderful in your home. If we think about the First Amendment, you have to understand that until, say, 1915, First Amendment was understood to be largely procedural. It protected speech against prior restraints, but not against subsequent punishment. This was a holding by Holmes in 1907. And so when the court imagined itself protecting speech, it was protecting it against certain forms of licensing, which had been associated with the Tudor and Stuart monarchies in England. And after the Glorious Revolution, prior restraints were rejected by the English government. And by the time you get to Blackstone, the notion of being free from a prior restraint was associated with the freedom of English speech. And it's that form of freedom which the court always interpreted the First Amendment as protecting. And you can see how extreme this was, that in 1915, Harlan Stone, the future author of Caroline Products, writes his first and only book on law and its administration, and he gives a summary of the important rights in the Bill of Rights, and he doesn't even mention freedom of speech. Freedom of religion, yes, freedom for due process, but freedom of speech, 1915, not even mentioned in the one and only major book by Harlan Fiske Stone. What happens is in World War I, the government begins to censor political speech in terrible ways. We have the Creel Commission on censorship that's supposed to gin up support for World War I. And most thinking Americans begin to say, you know, we can't have a government formed by public opinion and at the same time have public opinion shaped and censored by the state. And so by 1918, we see an unpublished opinion by Holmes, who's retreating from his own prior opinion in Patterson versus Colorado. And he says, you know, maybe, just maybe, the First Amendment may apply to subsequent punishments, that is to say crime, as well as prior restraints. But this opinion is never published. And what is published is Schenck versus United States. That comes out in March of 1918. And he puts that out as dicta. But at the same time, he permits Schenck to be punished for distributing leaflets to the troops, punished under the Espionage Act of 1917. The Espionage Act of 1917 punishes attempts to cause insubordination in the military. By the time we get to November of 1919, Holmes is facing a case for punishment under the Espionage Act of 1918, which is very different than the Espionage Act of 1917. And in the 18 Act, what's punishable is bringing the form of government into contempt. That's seditious libel. And so the way Holmes had conceived Schenck is speech can be evidence of an attempt to commit an act which can be made criminal. By the time you get to the Espionage Act of 1918, there's no underlying act which can be made criminal. It's just seditious libel, period. And Holmes's conceptualization has to be junked. And for the first time, he develops a theory of specific First Amendment protection for speech itself, which hadn't existed anywhere in any Supreme Court decision prior to Holmes. And this rapidly develops through what's known as the Holmes-Brandeis clear and present danger test, and it is applied to political speech. And the theory of the thing is given by Brandeis in his concurring opinion in Whitney and his dissent in Gilbert, where he says, look, public opinion is the product of what we all have to say. And if any person can't contribute, we don't have an accurate picture of what public opinion is. And so the state can't respond to what people want. And so if speech is being protected in order to form the public opinion, which the Wilson administration had censored, several things followed. One of the things that followed is if speech wasn't an effort to form public opinion, it wouldn't be protected. And that's what the court holds in the 1940s in a case called Valentine, saying commercial speech, advertisements, these have no First Amendment protection. They're out of protection at all. By the time you get to the 1970s, the court is prepared to extend protection to commercial speech, but it's really quite worried about it because there's a lot of academic commentary, including by Powell's former clerks. Powell writes, Powell is one of the justices who is on top of this move to protect commercial speech, saying this is Lakier. So to understand what Lakier is, you have to understand that in the early part of the 20th century, the court was protecting persons who are acting in the marketplace as autonomous actors. The autonomy of the person to do with their property what they will is an essential constitutional liberty. The constitutional revolution of the New Deal says, no, actually the liberty to do with what you wish with your property in the marketplace is not a constitutional liberty. The Congress and the legislatures of the state must be free to regulate commercial activity, and they can't be impeded by constant constitutional review. Notice that the First Amendment, like Lakier, imagines the person as autonomous, as participating in the formation of public opinion. And in that way, it's fundamentally theoretically at odds with the Lakier revolution, in that it doesn't, the Lakier imagines persons as autonomous, as does the First Amendment. But if you apply autonomy to commercial speech, you are imagining the commercial actor as autonomous in the manner of Lakier. And so the court's very careful to distinguish itself from this image of the autonomous commercial actor when it first creates the commercial speech doctrine. So it says the reason why we're protecting this is not because there's an autonomous speaker here, but because the listener is entitled to information. The court's very explicit about this in Central Hudson, written by Powell, who says the reason why we protect it is the informational function of commercial speech. People have a right to receive information. And in that way, they distinguish themselves from the Lakier line. And the doctrinal line which shows this is the idea of compelled speech. right from the beginning, the court is saying we can compel the commercial actor to speak. Right from the beginning, they are saying we can subject commercial actors to prior restraints. That's right in Virginia Pharmacy, the first decision to give protection to commercial speech. And so the court is trying to develop a different paradigmatic protection for commercial speech than for ordinary speech. For ordinary political speech, the actor is deemed as autonomous. You can't require speech. There's no prior restraints. And none of that is true for commercial speech. And that way of understanding it remained more or less stable until the 1990s. From the 1970s until the 90s, commercial speech was a product of the, you might say, the left wing of the court, the liberal justices. And it was opposed drastically by Rehnquist, for example, who didn't want any of this. And it was opposed at the beginning by Scalia. By the 1990s, the right wing of the court, led by Thomas, and then joined by Scalia, and eventually joined also by Rehnquist, begins to see that if you make the commercial speaker autonomous, you actually have constructed the analog of Lochner, and you can begin to use commercial speech doctrine as a method of striking down commercial regulations. The left wing of the court, Sotomayor, doesn't see this until relatively recently. Ginsburg doesn't see this until relatively recently. So there is this period of time when the left and the right are joining and striking down commercial speech regulations, which occurs right until, I would say, Janus, and relatively recently when the left has begun to understand the larger political framework within which this is happening. And now this has become an engine. You see it in compelled commercial speech cases. And in decisions like Sorrell, like Janus, like NIFLA, the court has begun to protect the commercial speaker as an autonomous speaker. This is striking because Thomas is in the lead on this, and yet Thomas wants to reverse New York Times versus Sullivan. I mean, it's this striking revolution in what First Amendment priorities should be. First Amendment priorities had always been political speech, and here you have Thomas trying to no longer give protection to commercial speech, but to give protection to commercial bakers from anti-discrimination law. And this seems to be where the court is heading now. And that's a short encapsulated history.
Fantastic. Thank you, Robert. That's like a whirlwind of First Amendment history. So Genevieve and Beth, I would love to hear your views on how you see the court's approach shifting in recent cases. Robert mentioned Sorrell and NIFLA, Reed, Janus, Masterpiece Cake Shop. How do you all understand these shifts?
Amanda, actually, can I go back a little bit to the narrative? Because I think maybe I disagree with some of the framing, and it might be productive to talk about that a bit.
That would be great, but only if you describe tell us who your adorable interloper is.
Oh, yeah, sorry. She wants to be on Mommy's lap. This is Vivian.
Hi, Vivian.
Want to say hi? She does not want to say hi. She's not very impressed with our conversation, so she's drawing. I agree completely that when the court starts framing commercial speech, it suggests that the primary interest it's thinking about is the interest of the audience, the listener's interest, rather than the interest of the autonomous speaker. But this gets complicated very quickly because there come before the court a series of cases, or the court chooses to take a series of cases involving regulations. For example, one regulation that requires a New York electrical utility, a privately owned electrical utility, to include in the mailings that it sends out to subscribers, I think every other mailing, it had this newsletter that surprisingly promoted the company, promoted electricity sort of a use to consumers. And the regulatory body thought that this was presenting consumers in the midst of an energy crisis with a very one-sided presentation of the relevant concerns surrounding the use of electricity. So it turned to, I think, a pretty prominent local sort of environmental public interest group and mandated that they should be allowed to include their newsletter in the mailings that the privately owned electrical utility sends out to consumers, I think, every billing cycle. And the court says, no, you're not permitted to require this electrical utility to use its mailings to communicate messages it doesn't like. Now, one would think that if the court's only concern is with the audience's interest rather than with the autonomous interest of the speaker, this would be an easy case. There would be no issue. There was no evidence. I mean, all the evidence suggested that consumers would be better informed if they had these mailings. It would be to the benefit of sort of the country as a whole, public welfare as a whole, for this information to be circulating. And what better way than to make it in the mailings that the electrical utility customers are getting? But the court says no. And it applies the same concern with compelled speech that it applied in non-commercial context. It just imports that into the commercial speech realm, even while recognizing this to be a commercial speech realm, a commercial speech case. So I agree completely with Robert that the court, and I agree as well, out of anxieties about replicating Lakier, has emphasized in a number of its commercial speech cases that these are totally different from other kinds of cases, because the interest here is not in the speaker's autonomy interest, but in the audience's interest. It hasn't put its money where its mouth is. In practice, it has treated the interest of the commercial speaker in some cases, like the electrical utility case, as trumping the interest of the audience, as if, as it often does in its other cases, as focusing on the autonomous interest of the speaker. Now, it has been complicated and ambivalent on this point. I agree. But what is notable to me actually about the sort of this remarkable, what Justice Kagan called the weaponization of the First Amendment that has happened in recent years, where the First Amendment is being used to strike down all kinds of commercial regulation, is that in many cases, this actually isn't in the commercial speech cases. In the commercial speech cases, the court seems to have reached, or courts seem to have reached a, I don't know if you, maybe equilibrium is too strong and there's pushing at the edges, but a position where it's not impossible for, it's not impossible for the government to justify commercial speech regulations. That is to say, the same strict scrutiny that is applied in other realms does not apply here. It's definitely more difficult when there's a commercial speech analysis brought to bear. There's a tax imposed on the government when it wants to regulate commercial speech. But in fact, although I don't think it's true that the only interest at stake in these cases anymore, and for decades now, is the interest of the audience, I think that autonomy interests are a thing that courts care about. What's interesting about the commercial speech cases is it hasn't meant that no regulation survives. And so I'm not sure what to think about the analogy to Lakier. One might say it is like analogous to the Lakier era, where the court didn't strike down all of these economic regulations, but it gave courts a lot of leeway to pick and choose. But if we think about where the assault on the regulatory state is happening, I'm not so sure it is happening within the commercial speech cases.
I have to say that looking at this as a practitioner, as someone who's in the courts, I find it fascinating to have this overall perspective. And Robert, that was just terrific to kind of look at these past decades, because it reaffirms that I think that what everyone, it is quite obvious, knows is this change is incremental. I mean, it's just the way the common law works, but also it's what the Supreme Court does is how the lower courts react to it, then it's how regulators react to that. And so part of what you see is, I think, this, as we often say, chipping away in a couple different ways. So there's the chipping away of the commercial speech standard itself. What's going to be commercial? Is something completely non-controversial? Is it just factual? Is it going to be protected as commercial speech? So that's being narrowed. But at the same time, I think you have to look at the other doctrines and see how they may be affected by this. One thing that you certainly see is there, a lot of these are broad, as we've talked about before. They're about hot button issues. They're about more socially related issues, even though they're in the context of business cases, having to do with the labor unions or abortion. And I think as a business lawyer, you always have to remember too that your clients don't necessarily want to be a speaker sometimes. They want to have their healthcare plan without being judged about what their religious views might be about what's included in it. That's not always the interest out there. So you see that reaction to what really is the practical impact of this going along. So there's a time lag also, right, between the doctrine changing in the Supreme Court and when it actually trickles down. So that's something that is quite impressive, I think, recently, because it is starting to have a broader impact. I think that's what we're seeing in the past couple of years, that there are more of these kinds of cases, particularly the compelled speech cases. There are other cases, as Amanda mentioned, having to do with not pure speech, but like the public accommodation case and the masterpiece cake about the baker, where everybody thought it was going to be a huge case, and it turned out to be so narrow, not a speech case at all, barely, not even the free exercise claim that was brought, but something else about religious hostility. So that's a good example of how, slowly those arguments will ultimately be addressed by the Supreme Court, because they had the opportunity, they didn't do that. So that also shows that there's, I think, some hesitation and some prudential awareness going on about the actual implications of that. And particularly in light of what you both were just saying about perhaps different justices now starting to see some of these doctrines differently.
No, when you think about these changes, it's not that in Lochner era, all regulation of the marketplace was struck down. Far from it. I mean, the court approved far more than it disapproved. But what it does do is it puts all of the regulation under a cloud, and it makes all of the regulation litigatable, which increases the cost of doing it. It chills the enactment of this regulation. And to the point that you're making, Beth, about it being incremental, what you see now is that the lower courts are stuffed with Trump judges. And these judges are extremely ideological when it comes to these sorts of questions, and one can expect to see this accelerating in a terrible way. So I think the pattern you describe is correct, and I think it's going to be accelerating in the next 10 years, given the nature of our federal courts at the moment. And Genevieve, I think you're quite right to point to the PG&E case, but when the court considered this directly, the case is known as Zouderer. And in that case, there was both a restriction on the commercial speech of attorneys, and there was the compelled requirement in their advertisements to put a certain thing. And the court had two different forms of analysis. One was Central Hudson for the restriction, and the other, what we now know is the Zouderer test, which basically said reasonable if you want to compel speech. And if you look at the way the marketplace is now regulated, remember, after Reagan, there was a reaction against command and control regulation of the marketplace. So they don't say you can't do this, you must do this. Rather, there was this effort to shape the marketplace through information signals. You give the consumer more information, they'll make the right decisions. Paradigmatic here would be, for example, food labeling requirements. So we don't say you can't put sugar in the food, we just say on the label, show that you have 5 grams of sugar, and the consumer will make the appropriate adjustments. So much of our commercial regulation now goes through information forcing provisions, and that was all provided by Zouderer. And what you see in the lower courts now is a sustained attack on Zouderer. Mm-hmm. And this is, one of the remarkable things is in NIFLA, the court doesn't retreat from Zouderer. It even in some respects expands Zouderer, mm-hmm. But yet in these hot button issues of the kind that Beth just talked about, it doesn't abide by Zouderer. So you're going to see this spread of this libertarian, commercial libertarianism into First Amendment areas. And the consequence is not hard to foresee. One is the First Amendment is going to be weakened because it's going to be more expansive. And the second, when you need it, like when you see the police tear gas demonstrators for no good reason except a photo op, it won't be there because it will have been diluted. I mean, these are obvious consequences that we can expect.
I don't
disagree. Point two, I would just say that the consequence on the regulation point is interesting because it doesn't necessarily mean there's going to be a void. There may be a return to the command and control type of regulation. Mm-hmm. And it's that interaction between the courts and the executive branch. The executive branch may change and regulators may say, okay, well, if that information disclosure provision is not possible because of speech and there's something more based on conduct to be done. So I think it's, somewhat unpredictable and interesting to think of, the consequences may not be what people anticipate.
So can I just say on Zouderer, I think I agree completely that what we're seeing both in the lower courts and egged on, I think, by what happened in the NIFLA v. Becerra case, where Thomas seems to do two major, I mean, again, he adopts Zouderer, he incorporates Zouderer, he recognizes that there's this lower standard for disclosures, but seems to beef up the standard in significant ways in at least two respects. One, he adopts what I take to be a new conception of what it means for a disclosure to be non-controversial, which is Zouderer, when the court writes Zouderer, it says that, well, you can apply pretty deferential scrutiny to disclosures because they add to the information, they add to the marketplace of ideas, so long as they are factual and non-controversial. And I had always read that, and I think the lower courts, the courts had always read that to mean, well, the information must be both about facts, and also the facts must be non-controversial, which is to say there must be facts that are broadly understood to be true, because at the edge of the factual universe, the edge of things we know about the world, it actually turns out that when we're talking about facts, we actually may be engaging in similar kinds of things as when we talk about opinion. So when physicists claim that string theory accounts for the universe without much more evidence, they're actually stating an opinion, and the First Amendment protects opinions. And so the court was saying, no, Zadra applies to disclosures that are really about facty facts, the kinds of things that there's really no disagreement about, because obviously we want to protect the ability of people to express opinions. And that meant that there's a sort of a relatively broad conception of what counts as non-controversial. It's not meaningless, but it extends to a lot of factual disclosures. Thomas in Becerra says, no, this is how I read it. I mean, feel free to disagree with me because I think this is a amazing reading. He says, no, if a non-controversial disclosure is a disclosure that's not about a controversial fact, which is not about an item in political controversy. It's not, the question is no longer, does everyone agree that this is a fact? The question is this fact about something that's controversial? Which, as you can imagine, narrows the range of facts to which this lower level of scrutiny applies. And so therefore, absolutely, it makes it harder for the government to mandate disclosure. And the court also seems to impose much more analysis about whether or not the disclosure is burdensome. And so I was looking at a bunch of court cases recently that have struck down disclosures just because they're burdensome. There was a case that had I think this was coming out of California. It was a disclosure that sugar is bad for you, and it took up 20% of the ad space. And the court said, well, but all of your scientific evidence says that 10%, if it takes up 10% of the ad space, that's sufficient to attract consumer attention. And so this is double that. So no, it's burdensome, which is very rigorous. And even then said, and we're not saying 10% would be okay. We're just saying this isn't 10%, and so it's definitely not okay. So there for sure is a fight about what kinds of disclosures commercial speakers can be required to engage in. I guess my pushback was a little bit that the idea that this stems ineluctably from the emergence of this commercial speech category, or even that it's the only side of the fight is when it comes to commercial speech. So what's interesting about the commercial speech cases is for 30 years, and maybe Beth, you think that I'm just not seeing the incremental change, but the court develops this new category called commercial speech, and it vacillates for a while. It's not quite sure how deferential or how strict to be in its scrutiny, and it comes up with this kind of intermediate scrutiny that imposes a tax on the government to be sure, but doesn't invalidate all regulations. There's plenty of commercial speech regulations get upheld, and also it has this additional Zordera standard for disclosures because it wants to get information out there. Now, I don't think personally that it's because the court doesn't recognize that commercial speakers have autonomy interests. I think it's because the court recognizes that in commercial transactions, there is a power inequality between the speaker and the recipient, because the speaker has all the information about the product that they're selling, and the audience doesn't either have that information or have any way of getting that information. And so the court doesn't want the audience to not be able to know relevant facts. And so you can think of disclosure requirements as part of the court's effort to make sure that commercial speech is not misleading. So it comes up with this equilibrium. And then what we're seeing in the last 10, 15 years is an increasing anti-regulatory push, but it's not only, and maybe it's not even primarily in the commercial speech cases. It's not happening via the sort of the central Hudson test, which is the primary test for commercial speech regulation. It's happening by this attack on disclosure in Zordera. It's happening in when it comes to disclosures outside of Zordera. So Nifla v. Becerra involved a challenge to what the lower court had understood to be a doctrine that wasn't a commercial speech doctrine, but also had to do with the regulation of economic life, and also gave the government more room than would otherwise apply. And this is what was, the professional speech doctrine. The court rejects that. Janus was not a commercial speech case. Janus involved the regulation of union dues, but it involved the regulation of economic life. And so what we're seeing is in many, many different domains of First Amendment law, many of which are not doctrinally understood as commercial speech regulation at all, similar kinds of push towards increasing protection for the autonomy of the speaker, and increasing impatience or a lack of deference to the government's kind of welfarist concerns with public health and safety.
So so a number of things that you all have pointed to is this idea that there are sort of enormous, maybe glacial, but very fundamental changes that are happening across First Amendment doctrines, not just within commercial speech, but also within commercial speech. I'll note, in addition, that like the standard of review under Central Hudson has been ratcheted up very close to what we might understand to be something closer to strict scrutiny, even though it's ostensibly intermediate scrutiny, but that really a lot of the more important things are the interrelationship, let's say, between commercial speech, qua commercial speech, and all of these other related areas. And they are disparate. They range from things like intellectual property law to things like abortion regulation. So I was hoping that what we could do is we could begin to think about what those relationships are and talk about what they may mean for the future and how the court's commercial speech doctrine or these larger shifts may affect those things. So one of the things we've already been talking about a bit is NIFLA. But I'll say, you know, and one of the themes, I think, of the panel and of the case law is that there's been a shift towards, let's say, robust libertarianism, or the idea that there should be the recognition of strong autonomy interests in a variety of different First Amendment speech contexts, okay? But a lot of the cases that have hit the court, you know, some have been brought by libertarian groups or by the business community. So we can think of cases like Janus or Sorrell, but a bunch of other cases that have hit the court have been brought by significantly the faith community in the context of religion-driven claims like NIFLA or Masterpiece Cake Shop. And so I guess one of the questions that I want to ask you, first, we have a question in an appropriate question in the chat from Casey Maddox asking, why is NIFLA being listed as a commercial speech case? So if someone could explain how NIFLA relates to commercial speech or how these play out. But also I wonder for you all whether or not, you know, Smith, the lower level of review that you get for generally applicable neutral laws regarding religion, has maybe arguably been pushing at the same time that the speech clause has become more aggressively libertarian, has been pushing litigants arguably into the speech clause who might otherwise sort of be religion advocates. Beth, I know you litigated Masterpiece Cake Shop, but if you all have thoughts about this kind of connection between the religion, say, type of case law, and specifically NIFLA, and the kind of like more libertarian commercial speech front, I would love to hear.
One thing I'll just set up, I guess, as you're talking about the speech clause, is the Smith case is definitely up for reconsideration next term at the Supreme Court in a case, Fulton, the city of Philadelphia, where the city wanted a contract with foster care agencies and had a non-discrimination provision and said that, you know, you could not discriminate against allowing foster or adoptive children with same-sex couples. And so that has been brought now up to the Supreme Court. And the question is whether they're going to reconsider that Smith case. And if they do change the religion doctrine again, I think what you're saying, Amanda, may be that the cases may shift back maybe where they more appropriately belong under the religion clause rather than First Amendment clause so much. But I agree that that has been something in Masterpiece Cake Shop, the public accommodation case, where both these religion and speech clauses being brought in a case that you might have thought was at its core a religious case. So I think that bumping up against that doctrine with Smith, what happens on Smith and what they do, and whether they do revisit it, will have, I think, an effect on the types of cases and the nature of the First Amendment law development also.
And what do you all think of NIFLA? Is that, so Casey Maddox asked, why is NIFLA being listed as a commercial speech case?
One answer to that question is commercial speech starts out as something very specific. In Virginia Board of Pharmacy, they say, you know, it's an advertisement, basically, an advertisement for commercial services or products. But it immediately becomes clear that there's all kinds of speech that occur in the commercial marketplace that you can't define in that kind of narrow fashion. Young's versus Bolger, for example, where you have a pamphlet that's describing condoms as viewed as commercial speech. And the category blurs out. And in the last 20 years, I would say, it's blurred out also to include professional speech. So when you see a lot of laws regulating what doctors can say, they can't ask a patient about guns. And the question is there a special category of professional speech or is it commercial speech? And you get endless of these categorical questions. And the main thing to understand here is that there's that the commercial marketplace consists of lots of different forms of speech. And most of them a lot of it cannot be described simply as an advertisement. And yet, when the courts are looking around for a doctrinal framework in which to think about how to rate, commercial speech is what comes to mind, and that's the category which they use, and they use that also for professional speech. So, in this, at least for me, when I'm speaking about commercial speech, I'm speaking about it in that broad way, not the technical, narrow definition that you get in Virginia Board of Pharmacy, because that's in fact how courts are going to analyze it. And here, Amanda is pointing to an ambiguity in those who are now pushing against speech doctrine. And in the context of NIFLA, NIFLA was a case in which California required certain kinds of reproductive services organizations to post on their walls the notice that abortion services will be available in a certain sort of way, state supported. And the court conceptualized this as compelled speech. Query who's speaking, whether they're speaking or whether they're using the property, and why is that? And this goes back to the PG&E case that Genevieve was talking about. It actually goes back to a case called Woolley versus Maynard, where driving around with a slogan on your license plate, which no one would attribute to you, is being attributed to you as your compelled speech. So it's a complicated question about why you're being compelled to speak in this case, because no one understands that to be the voice of the reproductive service provider, the counseling center, which is posting the notice. But put that to one side, the court conceives it as compelling them to speak in the context of what is a quasi-medical procedure, not in some instances not licensed, but quasi-medical procedure. And so how do you conceive that? And how do you conceive it, and how do you put it together with a case called Casey, in which the court had said doctors can be compelled to tell patients certain things before they receive an abortion. So here you have direct compelled speech by the doctor, approved by the court without any First Amendment problem, and NIFLA, where it's not even them speaking, it's a poster, and that's a compelled speech which is undergoing this quasi-strict scrutiny. How do these two cases fit together? And Thomas distinguishes Casey by saying, well, that was just conduct. That was the practice of medicine. Well, whenever you see someone distinguish someone speaking as that's conduct and this is speech, you know that, protect your wallet because somebody is trying to cheat. And that's a completely dishonest distinction. And yet Thomas is pushed to it. And that's a sign of, on the one hand, his wanting to regulate the physician-patient relationship in the context of abortion in the name of the kind of moral social control of medical services that you were describing, Amanda. And on the other hand, his libertarian responses to the California statute. There's no way these two impulses can be reconciled. And the only way he reconciles it is an entirely indefensible and arbitrary distinction between speech and conduct.
Can I just say, though, in response to that question about why it's a commercial speech case, I think that's a great question. I think for the students who are watching this, it is really useful to constantly be thinking, why is this in one bucket and this in another? Because what you see when you look at this landscape of what is basically economic regulation, it really depends a great deal which doctrinal bucket you put it in, the level of scrutiny. And so what we see now is a lot of fighting about what counts as commercial speech, because commercial speech gets it is more rigorous, it's less deference than it used to get, but commercial speech regulations get more deference than non-commercial speech regulations, and the court is increasingly unwilling to recognize any other categories of exception outside of commercial speech, and then a very narrow unrelated others like profanity and obscenity. But so the government's best chance at defending its regulation is to put it in the commercial speech bucket. And then, of course, in response to that, litigators on the other side are going to say, this isn't commercial speech, this isn't commercial speech. And so I think from the 80s, really you see a lot of fighting about what counts as commercial speech. And the commercial speech emerges as this sort of very formalistic conception, very formalistic doctrinal category that sometimes expands and sometimes contracts depending on how the court wants to use it. But I think, in terms of principles, it's not obvious to me. I guess I'm curious what other people on the panel think. It's not obvious to me why whether something counts as commercial speech in the narrow doctrinal way in which the court has understood the term should matter. You know, what, there's this great case from the, I guess, the 80s called Riley v. Federation of the Blind, in which it involves, again, compelled speech. There's a North Carolina law that requires fundraisers for charitable organizations to disclose to the people that they're asking, the homeowners they want money from, how much money of the money that they receive from homeowners in the previous year did they actually give to the charities. And North Carolina enacts this law because it had found in the previous year that the top 5 fundraisers were keeping from 85 to 95% of the funds that they retained, and assumed that people would want to know that that was the case when they give this money to this fundraiser. Most of it is, the huge majority of it is probably not going to go to the charity. So the court, but there's this big fight in Riley about whether or not this is commercial speech because you're engaged, you're asking for money, or whether it's non-commercial speech because you're doing it on behalf of charities and for non-profit organizations. And the court finds that it is non-commercial speech, and then that's it. The regulation is toast. It strikes it down under strict scrutiny. But to me, that's irrelevant. Maybe it's not commercial speech, but it's not obvious to me why it should matter whether or not it's commercial speech in the formalistic sense or not commercial speech. The regulation is doing the same thing in either case. It's trying to ensure that consumers, the recipients of this information, have the relevant facts necessary to make the informed decision about whether or not to give this money. And so I always look at Riley as a sign of how problematic this sort of very rigid doctrinal, very formalistic doctrinal distinction that the court relies on between commercial speech and non-commercial speech, how problematic that is. But I'm curious, what do other people think about sort of this very defined commercial speech bucket?
I think that one of the problems with the bucket is yet another aspect of whose speech it is. Robert had mentioned this about the NIFLA case. When you're talking about the Riley case, that is the speech. The actual entity is being required to say something about information they have about their business, about their enterprise. Whereas the NIFLA, it was about the state. It's about what services were available for the state. It was not the only thing about forcing the office where the poster had to be posted to suggest it was their speech is because it had to be posted on their wall. It wasn't at all represented as their speech. And it was, you know, giving this information about what was available through the state. So I think that's another question about the buckets when you're talking about whose speech is it? That was one of the questions that was coming up, was being argued. It wasn't decided in the Masterpiece wedding cake case. You know, whose speech was that? And frankly, once the wedding cake is taken to a wedding, who even knows who made the cake? You know, it's not like there's a big advertising saying this is my speech. So that was really a very interesting aspect of that case too. And so I agree with you, Genevieve, these buckets seem to be overly restrictive, and it's not just, you know, there's more than one vector going through there about why they are sometimes mislabeled.
What you see across buckets,
Go ahead.
sorry.
I was just going to say, one way to understand these buckets that you're talking about is take 2 paradigmatic cases and examine one's own intuitions about it. So we have a law which says if the New York Times is going to criticize the president, it has to reveal the relevant facts. That's one law. And your instinct is that's compelled to be, that's terrible because that's stopping what the New York Times can say about political matters. A second paradigmatic example is if you're going to sell food, display the calorie content. That doesn't feel the same way. One has a different intuitive reaction. And what you're calling strict buckets are really ways of accounting for those 2 different reactions. And at the root of those 2 different reactions are the sense that the speech is doing different things in those different contexts. The speech is in a different social setting and it's performing a different social function. And the category, while it's a mess and while it's loose in all the ways you describe, and is at the boundaries, of course, arbitrary, as all legal categories are, nevertheless is an attempt to capture that instinct about what should be constitutionally relevant when the state compels speech.
I'm not convinced, as you know. I'm less convinced than you about that. I mean, I think the disanalogy there between the New York Times and the calorie counts is what I referred to earlier, which is the power relation, the kind of the ability of the consumer to get information. So it's this is, I will say something controversial now, which is that
that's another way of saying the same thing. You're saying in some cases speech occurs between people who have different power relations and others they don't. And that's ascriptive. That can't be descriptive. There must be an ascriptive distinction you're making, because sometimes the consumer knows more than the producer, sometimes less. But ascriptively, we're going to establish it in law as a situation in which there's this asymmetry you're talking about. But that's a way of unpacking the instinct.
But if we are thinking in those terms, it's not clear that it matches the commercial speech, non-commercial speech line very well at all, or ever has.
The line.
Sorry?
Then we should reestablish the line so it matches that.
So yeah, so one way to read what is happening right now, I mean, I guess that you could, I think looking at the current cases, you can interpret them in two different ways. So one is there are transformations that are occurring throughout the doctrine in lots of different ways, such as this increasing emphasis on speaker autonomy, the sort of embrace of libertarianism. I was going to say in response to Beth, I think another theme that you see across the doctrine in all these different buckets is this conflation of property interests and speech interests. So one of the things that in the early 20th century, the court said, the New Deal court said when it was inventing the modern First Amendment, is that speech is in a preferred position over property. That, you know, sometimes we have to violate the ordinary rules of property or not apply them when it's really important to produce the kind of, you know, diverse democratic public sphere that the First Amendment, we're now going to understand the First Amendment to produce. And so that's the sort of the formal line that the court takes for a while and then sort of moves away from it. Frankfurter never liked that. But now what we see is, I think property is understood as the primary locus through which speech occurs. The court, this is sort of classic economic libertarianism, that property is the base of all other rights. And so the court has been in lots of different buckets. I think commercial speech bucket, the PTE case is an evidence of this, but lots of other buckets too. The court is saying, no, the way in which we're going to protect the speech interest is by protecting your property interest. And so we're not going to do the kind of more fine-grained analysis that you were asking about, which is to say, is this actually speech that's going to be associated with you, and does this actually harm your ability to communicate your own message? We're going to protect the right of the property owner to control all the expressive uses to which their property gets used, bar none. And that is what it means to protect the First Amendment. And we can think about that in the campaign finance cases. That's one way of thinking about the campaign finance cases. No restrictions on your ability to buy and spend is consistent with the First Amendment, because we're going to equate property and speech very tightly. I think Becerra's Willie v. Maynard is an early example of that. I think Riley, the charitable solicitation case, is an early example of that. And Becerra, you see it sort of profoundly. It's now the climax, or one in a sequence of many, many different cases. But note that these cases wend their way in and out of the commercial speech cases. And so one way to think about what's happening in the commercial speech cases right now is that there are all these phenomena, all these changes that are occurring, and they're occurring both within and without commercial speech. Another way is to say that, the way to think about it though, is that the commercial speech doctrine is actually playing this really important role in the court's thinking right now, because so long as there's commercial speech, it can say, well, we can apply strict scrutiny everywhere else. We can have a very uniform rule everywhere else, because we're not doing too much of an assault on the regulatory state, because we've got this nice commercial speech doctrine that gives intermediate scrutiny. And there's another way of reading it, which is that the commercial speech doctrine is now this is why all the fighting about what's commercial speech, what's not commercial speech is happening, because the court seems pretty okay with Central Hudson, with intermediate scrutiny for this relatively narrow band of regulations. But if you're outside of that very sort of special area, then we're going to apply very, very rigorous scrutiny and strike you down. And
but
so,
when you were talking about these labels, I wanted to ask both of you. I mean, we keep talking about commercial and non-commercial speech. We used to talk about political speech, that was the label that we all used to talk about. And we're not talking about political speech all of a sudden in this label. And is that what we mean by non-commercial speech? Or is it that so much more of commercial issues are being interrelated with social issues, and so is that why it's tending more to be speech, which we mean it's all becoming political speech? What do you think about those labels as you see them? Because even the way we're speaking isn't using the labels that would have been used.
Well, political speech, that notion comes out of Meiklejohn and Bork, who were predominant First Amendment theorists a while ago. And part of the problem is, of course, it doesn't apply to much speech which everyone understands should get full protection, like movies or novels or art. And everyone understood that to be like essential First Amendment protected speech. And yet it was odd to call it political. And so the notion of it being political, qua political, kind of dropped out, and one needs a different way of describing it. I myself think, the court has used often the phrase public discourse. It's an attempt to change public opinion, which art does, which people do, and which, when you're selling a product, is not an attempt to change public opinion. It's an attempt to sell a product. If you're a physician giving advice to a patient, you're practicing medicine. You're not trying to change public opinion. There's lots of forms of speech act which aren't described that way. And that, I think, myself, looking at it sociologically, tends to be the ground of distinction here, which is why the earlier question from the audience was a good one. Why are you calling it commercial speech? It tends to be a difference between, on the one hand, speech directed toward the public, toward public issues, and I'm using the word public here instead of the word political, versus speech which is, and here I'm going to be a little controversial, a more privatized interest. I want this from me. I want to sell my product to you, or I'm giving you advice as your lawyer. And this tends to be a cleavage that runs through the speech. But on the other hand, the First Amendment itself just speaks in terms of speech. Freedom of speech shall be provided. And so you have justices who are otherwise astute, like Souter, who will say what the First Amendment does is protect, and I'm quoting him now, speech as such. And when, for example, the Third Circuit comes to a regulation of physician speech, can you regulate the speech of a physician about, say, guns? The court will say, well, he's speaking, and that's all we have to know, and it should be regulated the same way any speech is regulated. The minute you make the move of saying speech as such, and every time anyone opens their mouth, they're speaking, you're in terrible trouble, because that means everyone is always, everything we do is through speech. And you need these distinctions, arbitrary as they otherwise might seem, in order to decide when courts are going to get in the way and when they're not. These distinctions kind of proliferate. But along this axis, I would say, generally speaking, that's my observation of how the courts are doing it.
Yeah, I think it's a really interesting question, though, about why this move to talk about speech versus, or public discourse, maybe public speech on matters of public concern, to use sort of some of the court's language, other language, versus commercial speech. There has been, I think, since the early 20th century, again, the effort by the court. I mean, this is the New Deal court. It wants to allow the New Deal state to survive and prosper. And so it makes this distinction early on between economic regulation, to go back to how Amanda started out the framing with the panel, economic regulation and non-economic regulation, and wanted to give a lot of deference to the government when it's engaging in economic regulation, so that the government could regulate worker safety and could protect the consumers. And while at the same time the court didn't want to give total deference to the government when it's regulating fundamental civil liberties. And so it makes this nice distinction, as Robert was referring to, between sort of this privatized world of commerce and this public realm of discourse. Now, I think I've just been thinking about your question about the religious groups bringing these challenges and things like Masterpiece Cake Shop. I think that line between this public world of discourse and this private world of commerce was actually never stable or clear. But I think it's increasingly unstable and unclear. And it's evident how complicated this line is, because it turns out, as all these groups are saying, as the Becerra case, I think, illuminates, the world of commerce is often a world where a lot of sort of religious convictions, philosophical convictions, affiliations, associations, ideas about the public realm generally play out. It just happens that we live in a capitalist society where lots of the ways in which we interact with other people is through the market. The way in which we transact speech primarily is through the market. We buy books, we buy a ticket to movies, we produce things that then are sold, or we put things on internet platforms that are make money by selling advertising and selling consumer data. All of this is heavily commodified. And so I think some of the sort of what we're seeing with the court applying this sort of very, well, if it's not commercial speech, then it's speech as such, and everything gets strict scrutiny, and that's sort of, or at least we have a lot of power to deregulate, is a legacy of, I think, the sort of early 20th century conception, which is First Amendment conception, which is, well, if it has to do with sort of public matters, then there's almost no regulation. The government can almost never regulate speech. But if we start to have a more expansive conception of how things affect public matters and what speech is publicly relevant, then the First Amendment starts to look extremely deregulatory. And I think that's what cases like Becerra really push us on. I mean, I think even in his dissent, Breyer acknowledges that that there is a significant harm to the group, these crisis pregnancy centers, who are, for religious reasons, vehemently opposed to abortion, having to put on their walls of their crisis pregnancy center that they have produced, they've created out of spiritual convictions, a letter, a notice acknowledging that there's publicly subsidized abortion available in California. That is harm to them, because this place is not just a place where there's medical care provided, or some forms of very poor medical care provided to pregnant women. It's also a place where all kinds of sort of political and religious work, there's projects involved. They're trying to change public perceptions in just the way that Robert was talking about when he was talking about public discourse. They're just doing it not by selling newspapers, but by counseling pregnant women in their clinic. And that is like a little bit like the New York Times having to put on its front page an editorial saying things that it doesn't want to say, or acknowledging the existence of things it doesn't want to acknowledge. And it's not obvious to me that I see that there are factual differences, but it's not obvious to me that they are so different. I think one mustn't dismiss the sort of very significant public discourse that happens in these commercial spaces, and that's why these categories become really difficult.
Well, I think NIFLA one of the difficulties of the NIFLA case is that if you look at it from the point of view of the counseling centers, I think it has the characteristics that Genevieve describes. This is their effort to influence what people think about reproduction, and you are influencing that. On the other hand, if you look at it from the point of view of the consumer, the woman who's going there, it's pure consumption of a service, and it's what I would now controversially call commercial speak. They're just trying to get a service. That's all they're trying to do. They're not trying to affect public. And from their point of view, they're receiving a service, and the speech is received as the speech relevant to the provision of a service. So in that case, it depends on which point of view you take to provide the constitutional characterization of the kinds of speech at stake. That's what makes that a complicated case.
I think also it's this idea of how you analyze it, understanding that that might be very offensive to post it in the thing, but is that because it's your speech? Well, no, it's because it's someone else's speech that you disagree with, that you don't want to convey. And so it's that idea of how you analyze it, I think, that does end up being a real reason why are you calling that commercial speech? Whose speech is it? I mean, you could say it's government speech that you're just being required to provide. And is that different than you being required to provide non-speech, drugs that have been approved that are safe? There's certain things that the government does. And I'll just throw this out there. I think Amanda's written some about this. I mean, this whole development about the First Amendment being used to challenge government regulation in this way that we've been talking about comes up at the same time. There's a real move towards challenges to the administrative state in other areas, like the Chevron deference area, even all kinds of that, non-delegation authority. There are lots of things that are going back, I think, to kind of questioning some of how Genevieve was describing the New Deal, these health and safety issues being regulations, not just that they're now being envisioned as speech restrictions. There are actually other avenues under which there are challenges arising to, exactly how that part of commerce should be regulated or not regulated, whether the marketplace takes care of it, and they're just different schools of thought. So that's all happening at the same time.
Yeah, this notion of making you speak versus conveying the speech, though it's mediated by the concept of property that Genevieve was talking about. Basically, conveying is I'm making you use your property in a way to convey, not that you are. And it traces back to this decision, Woolley versus Maynard, which I think is Rehnquist said, who's making anyone speak here? I think Rehnquist was correct in Woolley. I think it's a mistaken decision. So imagine the government condemns your property and it requires you to put on your property, notice condemned or unsafe or something like that. Is that making you speak? Or is that, in what sense is that a speech, a First Amendment question? And that's but that's what these cases, a case like NIFLA and a case like Woolley puts front and forward. Like, why should we consider that a First Amendment question, as opposed to the government being able to regulate, make a property safe, if it's condemned and therefore, whatever, like that question.
So this is terrific. I think I very much agree with you, Beth. And I think your question about what transformations in culture are happening is really key. I think one of the things this conversation has highlighted is a lot of the questions now are about essentially the standard of review and how do we characterize different social interactions to decide what standard of review, either something more like heightened strict scrutiny or something that's more deferential to the state to permit regulation of things like worker health and safety, things that mid-century were considered very important and requiring of more judicial deference. And today we're seeing a shift potentially away from that, right? And the way in which the court is doing that is arguably formalist, right? Or essentially saying, okay, we're just going to give like more stringent scrutiny everywhere. And you see this also in the Reed case, Genevieve, which you've written about. But I guess one thing I want to ask you all is, do you think that these trends are sustainable? Do you think they're practicable? I mean, Robert, do you think it's practical to characterize all of commercial life as the public sphere? Beth, do you think that the courts are going to go with that, right? What do you think the new justices on the court are going to do when faced with these next set of questions? We now have a newly configured court. Is this going to continue in this direction, or are we going to see sort of like a cutting back as the court says, oh, maybe I don't want robocalls, or maybe I do want, disclosures on my heart medicine?
Okay. So many thoughts. Can I just jump in?
Sure.
So two thoughts in response. So one is, well, I think Justice Kavanaugh is fully on board, and I think the newly reconfigured court is going to be only more of what the old Roberts Court has been. I don't see any evidence of any changes, but I don't think that means that everything is going to be struck down. I think the court, in its First Amendment jurisprudence, has been pretty careful, as I was suggesting when I was talking about commercial speech before, not to draw lines that are unsustainable, that require too much invalidation, that it produces political blowback or undermines the ability of the state to function at all. I mean, I think this is why Master V's Cake Shop was so difficult for the court, because it didn't want to have a ruling that said that every public accommodations law is either invalid or has to have these sort of very major exceptions on the basis of the First Amendment. And so it was really, I think, torn about what to do there. But in its other cases, even in cases like Sorrell or Niffler, when it makes these sort of very strong proclamations about what the First Amendment is, lower courts, there's still plenty of room for lower courts to narrow, to domesticate, and there's still all these exceptions. There's the Zorda disclosure standard, there's commercial speech. There's this very convoluted doctrine that gives courts a lot of outs to strike things down if they don't like them, or to uphold.
Which is to say, we should just be worried about, the sort of like robed people ruling the country. Is that, are we concerned? Sort of rule of law concerns? Is that, you think, the biggest issue?
Surely we don't have rule of law concerns in America. I mean, who would think that there's problems with rule of law in this country right now? I guess is to say that I personally am not enthused about the idea of making this a fight about standards of review. I think the liberals in the court have been trying to work within this complex doctrinal architecture to push things in a way that can allow the government to do important sort of health and safety stuff. So I think both Kagan and Breyer are trying to, are often writing relatively narrow dissents in these cases, saying, as in Becerra, I wouldn't have decided it this way, I would have decided this way. My sense is, because that you see similar changes happening in so many different doctrines, that it has to be a change is only going to happen if there's a real challenge to this idea that the speaker autonomy is the primary interest that the First Amendment cares about, and that anytime a speaker thinks that they're engaging in public discourse, they have pretty much unconstrained autonomy rights to both speak and to use their property, to control the uses of their property. I don't think it's going to be solved by standards of review. I think there is this deep, this is my shtick, but I think that there is this deep fight that has to happen about the meaning of the First Amendment. Is what the First Amendment means that speakers, whenever they want to engage in public discourse in this kind of political or religious or social project, they get full autonomy rights to do so? I don't think that's sustainable, but I don't think it's ever been sustainable. I just don't think that's the way we should be thinking about the First Amendment. But I think the prognostication is that likely in the short term, we're just going to have a lot of fighting about standards of review, yes.
Beth, what do you think?
I do think that there is going to be this fighting within the current framework. I mean, I think it goes back to what we were talking about before. The standard review, it's going to be diluted, I think, the more that the court tries to meet a middle and just to accommodate, you know, their analysis, to uphold certain things and be careful and narrow. And so that is going to, if they're using the same kind of test and standard review, it's going to start diluting that, I think, in a way. But I don't see that, and also I think they're keeping Central Hudson. They're not throwing that out. I mean, Smith does seem to be one that actually they're framing in the words of actually revisiting. But these other ones, in the case for next term on the religion clause, but I don't think these other ones are going to be this breathtaking, written in a way doctrinally to throw out these concepts. But I do tend to agree with you, Amanda, that it's going to be more in how they're applied, how the standards are eased in some ways to prevent, you know, a radical change in some of that to be perceived, rather to have it just be in applying the standard in a way that goes more towards the deregulatory state, I would think.
It also strikes me that if that's true, Beth, that maybe the suggestion is, as the court sort of like fiddles maybe more around the margins as opposed to overtly overruling stuff, that they're taking away some of the possibility of political reaction, right? And that we might be concerned on that ground as well.
I think,
Robert?
I think standards of review are largely a red herring. So take a case like Holder. Holder is a case in which you're stopping what could be characterized as core political speech, aiding to foreign groups, and Robert says, I'm going to apply strict scrutiny, and then he upholds it by deferring to the so the stand, you can do anything you want if you're a good lawyer with any standard review that you want. And so
Nothing you want. I'll say I litigated Holder and lost it, so keep going.
So I mean, that's and you can get easy standards of review like Central Hudson and wrap them up to strict scrutiny, or you can ratchet it down to not strict scrutiny. In Posadas, he ratchets it down to non-strict scrutiny to anything. And in other cases, Central Hudson itself is virtually equivalent to strict scrutiny. So the standards of review give comfort to people who like formal tests. But in point of fact, as any litigator would know, you're litigating the facts of the case and what a court wants to do. And so it seems to me that the only thing that really matters in this case is what the court cares about. What are the underlying values that they're trying to use the First Amendment to protect? That's the central issue. And so understanding what they imagine the First Amendment is for, that's a way to predict how they're going to use it. So the court that decided NIFLA imagined that it's to protect speakers like the counseling centers with whom they identified. And they viewed this as viewpoint discrimination. That's Kennedy's opinion for foreign NIFLA, that the state didn't like anti-abortion pregnancy counseling. And that's what it was an effort to, in Kennedy's words in Sorrell, because he viewed it this way in Sorrell. It was an attempt to, quote, tilt the public debate. And there is on the right a real sense now that these laws are tilting public debate. If that's what they're imagining, then they're going to use whatever standard review is they can reach for to strike it down. And so to understand where this law is going, it's not going to be helpful to have a lot of formalistic categories. What's going to be helpful is trying to understand what the court thinks it's doing, what it wants to actually protect, what it views as valuable and not valuable about people talking.
And so what do you all think the court is most viewing as valuable, and do you see that changing in the near future or doubling down?
Well, I think I've said what I mean. I think the court cares about speaker autonomy in this very expansive sense, in this very libertarian sense, where speaker autonomy and the rights of the property owner and the rights of the speaker are closely intertwined. That's what it cares about. It wants to protect what Kavanaugh said last term was a robust private sphere in which people are free to negotiate their relationships with one another as autonomous individuals. It's the sort of, I think, very desocialized conception of human flourishing, where it's just individuals in the marketplace transacting.
See, I would have said that until I read Thomas's opinion saying New York Times is wrong. So where does that fit with this notion of robust speaker autonomy?
Well, but did anyone else sign on to Thomas's?
I'm just saying Thomas, for example. I mean, what is he about writing that when he's at the same time, I agree with you. I mean, very much into speaker autonomy.
I think it fits entirely because, of course, this conception of this sort of nice little individual automatons transacting their business in private with no government interference, which is very much the view that Kavanaugh suggested in his most recent First Amendment case, is deception because there's government power everywhere. And really what the court said, what Kavanaugh means is that we're not going to apply First Amendment principles to private law. We're just going to, so when it comes to the enforcement of property law, the enforcement of tort law, this is one way to understand it. It's very Lakierian. And this is, I think, what Thomas is doing.
But why is defamation private law in that sentence?
And what's happening with trademark, right? And intellectual property law.
Well, but that's different. Okay, but wait, why is defamation not?
But why? But why?
Defamation is just a civil tort. This is the sort of classic private law, and we want to give it to the states to decide how to decide.
No longer speaker autonomy. This is no longer speaker autonomy. This is something else.
Well, it's not speaker autonomy.
If we're going to let civil, ordinary, common law stuff govern, you're no longer protecting speaker autonomy because that law does not respect speaker autonomy in many, many ways. So you're going to need a different intellectual category to describe what they're doing.
This was the realist critique of Lochner, that the Lochner court always says what it's interested in is autonomy, 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 freedom of contract, and yet it's not respecting freedom of contract of the workers because the economic marketplace and the existing laws of property and contract are so stacked against workers that in fact it's not a autonomy protecting system writ large. And one might say exactly the same thing about the contemporary First Amendment, that people, speakers who don't have a lot of property, people who don't have the resources, their autonomy is not being protected in all these.
Robert, you're aggressively shaking your head.
Well, I think I can't hear. I would say, I mean, okay, well, until she recovers the thing, I would say, look, traditional private law, Lochnerian private law, did respect formal freedom of contract. That is to say, you made the contract, you're bound by it. They didn't care whether it was a real contract, whether it was really a meeting of the wills because they were the power imbalances, blah, 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 all that critique. But the point is, if you made it, we enforce it. And the state is going to come in and enforce only that which you have as a matter of formal legal properties done. So this is not analogous to the situation now. Because if you imagine First Amendment as enforcing civil torts, you are not imagining as forcing in any sense formal autonomy because these civil torts were disrespectful of speaker autonomy in all kinds of ways and are disrespectful of speaker autonomy in all sorts of ways. They are regulated through privacy torts, the dignitary torts, all kinds of torts. And so as a formal matter, they are not recognizing speaker autonomy. Unlike the Lochner area, where as a formal matter, they were. They just didn't care about the reality of it. Here, that critique is no longer applicable. So I don't, I am puzzling about what the categories are that really are motivating someone like Thomas. I think he wants to, I mean, you could, I don't know, actually. I could speculate, but it would be pure speculation.
Beth, what do you think?
Well, I think it's very interesting, Beth, and I sit here and wonder, how many of the justices really conceptualize and have a strategy for the long term like this. I mean, certainly we've seen some members of the court do that before. Chief Justice Rehnquist in another area of federalism had a very, very long-term view. And I wonder which justice really sees the First Amendment in this long-term view that Genevieve and Robert are so, debating so robustly about, exactly what the undergirding of the First Amendment is, and who really sees that as their, their bailiwick, I guess. And I think that the way in which the newly constituted court is going to approach this is going to be quite interesting, because without Justice Kennedy, it does change a lot of the kind of more practical, straight out, case-by-case adjudication, which I think Robert was quite right. You litigate the facts of a case. I do think the standards of review are a level of comfort, kind of red herring, but that is the framework in which you have to play the game as a litigator to do that. So when you look at going before the court and the justices, and a lot of them having, for example, I think Justice Gorsuch is quite interested in the deregulation of the administrative state. You know, I'm not sure who it is who is going to see the First Amendment in the next 20 years as their long-term game. And, you know, maybe they are right now kind of taking the initial steps with a much longer view towards that. And that is where it's really important. I think where you're talking about these underground theories, and it's not really going to make the label, they'll move the labels to what that would be. But I'm not sure. I don't think we've seen enough of that with this new court so far. Clearly we have this, I think somebody said the acceleration of these kinds of commercial speech cases. And I do think that, you know, maybe it will be Justice Kavanaugh or someone else. I don't know. Do you guys have a sense of a...
As a litigator, Beth, what do you think they actually care about?
I think different justices really care about different, you know, practicalities there. I do think Chief Justice Roberts has a real concern about the institution of the court that I'm going to imagine he never really thought he was going to have to be paying so much attention to. I think the current administration has shifted where Chief Justice Roberts has to be looking at the significance of the court. And I just think in some respects, he doesn't have as much time to worry about doctrinal development since he's worrying about the institution of the court and, you know, the significant importance of the role in our balance of powers and all that. And there's so much going on about all of the separation of powers litigation, the subpoenas and all of that. That's why I just, you know, think for him that right now it's got to be his focus. I'm most interested in the newest justices and what they're going to be looking at. And certainly they have a very long-term vision and are going to be on that court for a very long time. But I don't really see, I mean, Justice Kennedy saw himself as a First Amendment justice. And I don't really see one of the other justices who's been on the court for a while seeing themselves in that same way.
Kavanaugh does.
Yeah, Kavanaugh, the newer justices.
Yeah.
Mm-hmm.
Do you think, I mean, you raised the non-delegation doctrine and Chevron before, and I sort of wonder if Justice Gorsuch, maybe Justice Kavanaugh, see the First Amendment as like, kind of like you said, as part of this sort of like set of potential deregulatory tools and within a larger project about reshaping the relationship between the administrative state and the Constitution. Whether or not you think, at least for Gorsuch, that seems to me potentially to be a large area of concern or project.
I think that's right. I think there's another area of big concern right now is the religious speech aspect of it and whether that stays under, you know, the speech clause or not. But I think that is something that's very important, and we can't, you know, disregard the fact that no matter what kind of doctrinal approach we want to talk about in NIFLA and, you know, all of those issues, I mean, that was about, you know, the core fundamental debate about abortion in the country and the religious underpinnings for that. So one thing I'll just throw out there on the other side, as I say that, there are also now more and more of these cases we're talking about just not religious objections, but moral objections generally that aren't religiously based. So that is very interesting.
Right. And whether or not the court is going to feel comfortable permitting very broad potential moral objections to things like anti-discrimination laws. Are they going to feel comfortable saying, you know, it's okay if you have a moral objection to selling something to an African-American?
Here's a question that you can test some of this with. Suppose that California has a law saying that if a bank charges interest on their checking accounts, they have to post a notice from the state saying, this bank account charges interest. And there are, you know, public savings accounts that, let's say there's a thing like that. Is that NIFLA or is that different than NIFLA?
Well, I think it's different than NIFLA, which I think the court's going to.
Why do you think it's different than NIFLA?
Because I mean, I agree with.
If we concentrate on categories of property and speaker autonomy.
Yeah, it's not. That's why, I mean, I agree with you, I guess, Robert, maybe. I'm not sure if I agree with you. I potentially agree with you that, you know, something broader is happening that's not just about autonomy, not just about property, even though those are very core things, but something broader is happening, which is why, you know, I query what it is, but also I sort of have some worry about this kind of rule of law question. Even if we're not going to ground things in doctrines that are clear, what are we grounding them in? And I feel like for litigators and for everybody else, we need to know that. Okay, but wait, I'm going to interrupt myself to bring you your public service announcement, which may or may not be speech, which is your CLE code. Your CLE code, get your pen. Your CLE code is SCSU09. That's SCSU09. Okay, I read it 1 minute late, but SCSU09, write it down. You get your CLE code. Great, thank you. Back to our regularly scheduled programming. I don't know, what do other people think?
About what?
About Robert's hypothetical, right? Is the, you know, is that disclosure, or we should probably move to, I can ask you all some questions from the chat. We have some great questions in the chat, which go to some of the things I was hoping we were going to talk about, including, can you all talk a little bit, and this is a question from Roman Leal, is there any distinction between commercial speech in the trademark context, like the TAM case and other contexts, or sort of more broadly, can you say these shifts that are happening, what implication do you think they have for trademark and IP law broadly?
Well, I think the trademark cases are another example of where what we're seeing is sort of at the edges of the commercial speech doctrine, because I don't think in Mattel v. Temp, correct me if I'm wrong, I don't think the court squarely decides that it is a commercial speech case, the trademark regulation. It says, we don't need to decide this because even if we apply Central Hudson, it fails. And so we don't need to figure out whether this is strict scrutiny or not. And so there is this question about whether the regulation of trademarks is a commercial speech regulation or is an ordinary speech as such kind of regulation, the non-commercial speech, commercial speech regulation. And so it's part of the broader phenomena that we've been talking about, which is this kind of this whole bunch of important stuff that's happening around the edges of the commercial speech doctrine. I'm not sure, it's right at the periphery, maybe it's in, maybe it's out. It's like Schrodinger's case. We don't know exactly where it is.
But on that, I think it's really important because you can really tie it back to the whole property interest too, because the core of trademark, the whole point of trademark is to avoid consumer confusion. That's really all it's supposed to be, right? That's the theory. And that really is core property, right? Because it's the ability to have your property portrayed accurately, not to be confused with somebody else's. And it's that, I mean, that seems more, I mean, it can be justified in that way as being more, more commercial speech, serving those interests that one would think about, I think, for commercial speech. If you're just talking about for the purpose of trademark to distinguish the goods of different sellers.
Okay, but I think that Tel v. Tam shows, again, to go back to the hobby horse, how interrelated the political and commercial is. I mean, think about the regulation, the trademark provision that was struck down in Mattel v. Tam, which was about the registration of scandalous trademarks. This is all about the...
Oh no, we have a frozen Genevieve.
Frozen. So while she's frozen, I want to make two comments on this. First is, it makes no sense to say are trademarks in public discourse or remain commercial speech. You have to answer that question by saying how a particular trademark is used. So copyright could be in commercial speech, or you could use copyright in public discourse, as in the Harper's case, or it could be in commercial speech, as in some other context. So it's a malformed question to ask whether trademark is commercial speech or other. That would depend on the
trademark is different than copyright, I would say, Robert, because copyright can be used in all ways, but trademark is really supposed to be about commerce, right? That you're using it in commerce, whereas copyright.
That's not true. I mean, I could take your trademark and put it in a movie and cause confusion. And so there are a lot of trademark cases about confusion within like in novels and in movies, etc. Similarly, trademark is not just about confusion now after the Trademark Dilution Act. And so you could violate my trademark by diluting it. And insofar as you're doing that, it's very interesting to watch these judges who are very libertarian in the First Amendment context. Being libertarian is often, I completely agree with you, being associated with propertizing things. So Kaczynski is very like, there's no difference between commercial speech and public discourse. But when it comes to trademark dilution, he understands that if you could have you could bring a trademark dilution claim in a movie or in an editorial, then you're going to be very anti-speech. And so in that context, you'll say trademark dilution is only in commercial speech versus public discourse. So you see that distinction very much reaffirmed in the trademark context, and particularly in the dilution context, especially by the very judges who are libertarian and very propertized, because they understand there's a tension between these two things, like in copyright. Because if I can force my copyright against you in your movies and in your novels, I could end people talking in public discourse. The same would be true in trademark. I mean, a lot of songs, for example, get trademark claims against them, things like that. So the trademark itself is indifferent. It's how it's being used, which is the question. And so that's what makes a case like Mattel and the more recent one so complicated, because it doesn't correspond to these doctrinal distinctions cleanly between public discourse and commercial speech. At a minimum, it seems to be saying you can't stop offensive speech even in commercial speech, which I would say it's a reliable precedent for saying if a state is going to censor a commercial for being highly offensive, they're going to have to run into Mattel. That is a minimum, it seems to me, that the case stands for. And that's a step forward. We didn't know that before so clearly.
Is that so brass tacks, you don't think that the First Amendment is going to eat trademark / intellectual property law? You think it's going to be a more case-specific analysis, but you think maybe the categories of the doctrinal categories are going to shift further. Am I capturing you correctly, Robert? And Beth, what do you think?
Say that again?
So do you think that, the First Amendment's going to eat IP law?
No. But
No, nor do I.
There's the question of the intersection of First Amendment and IP law is going to have to be reworked.
Okay. That was the second part of my question. Right. Great.
Genevieve,
I think that Mattel was such an exception in the trademark area too, that they kind of had to resolve those two provisions that had been languishing there. But I don't think at the core that it's really going to affect it. No.
I agree.
Okay. Wait, welcome back, Genevieve. Do you have other things to say about IP law?
Well, it's just saying that I think Mattel is a really good example of how it's actually valuable to recognize that there's an intersection between the political and the commercial, because I would be curious what other people think, but I think the court was totally correct in striking down that provision in the trademark law. The government should not have the power to decide what is or is not a scandalous trademark. And both in Mattel v. Tam and then in Iancu v. Branchetti, it seems like the court was working within the sort of very historic First Amendment tradition in saying, we're not going to allow the government to be the censor of public speech. And if you want to name your band the Slants, and if you want to use derogatory language or whatever as profanity as a form of commercial merchandising, we're going to recognize that has value, like profanity in ordinary public discourse is value, and we're going to not allow the government to deny you a privilege on that basis. It can deny you the privilege of the trademark on all other kinds of basis. It's not going to, it cannot do that. In this context, I think that was completely correct. And it's not because the line between the commercial and the sort of public discourse is not a firm one.
I think on the other side, though, also those lines weren't really furthering the purposes of the trademark in the same sense as, distinguishing it. Everybody could be using profanity, and it still might not be serving the purposes of trademark. So that's part of it. We don't talk that much about the other side, what it is that the government can present to justify regulations, the health and safety and all. But so I think that was a big factor in that case.
Mm-hmm.
So next we have a question from Brenda, I'm going to say your name wrong, Dofskin, about the regulation of social media companies. We have a whole panel on social media regulation later, which I highly recommend that you attend. But one other question is about transparency and particularly privacy. Robert, you have done some thinking on this. How do you all see these kind of big shifts in, let's say, commercial speech doctrine, or more broadly within the First Amendment, as potentially running up against privacy laws and transparency laws about data?
Well, data isn't primarily a question about social media companies. It's a question of data privacy generally. And in Europe, data privacy is generically regulated. So that means anyone having any information about you that is processing that data is subject to regulation under something called the General Data Protection Regulation, the GDPR. In the US, we have sectoral data protection. We have it for privacy and medical information. We have it for credit information, but we don't have a general data protection law, although California is coming online with its protection now. And so this isn't a specific issue about social media companies. It's a question about any company that has information about you and how it's manipulating. Sorrell has a lot of dicta in it saying information is speech. And so to regulate the use of information is to regulate speech. We have a First Amendment problem. But that's a very odd way of understanding Sorrell, because Sorrell also says HIPAA, which is the regulation of medical data, is a perfect example of a good law. And HIPAA was far more privacy restrictive than privacy protective than was the law at issue in Sorrell. So if information was speech, that's a very odd thing to say, that the more speech restrictive law is constitutionally better than the non-one. So a different way of reading Sorrell is not that information is speech, but that information, like anything, can be regulated for the wrong First Amendment reasons. And here, Kennedy seemed to be saying it's regulating this thing, this information, in order to tilt public debate. You could be regulating cross-burning, you could be regulating all kinds of things for the wrong reasons and have a First Amendment problem. That's Texas versus Johnson, that's RAV, etc. And that's a better way of reading Sorrell, because if you say information, it's like what I was saying before about trademark. A trademark is neither intrinsically in commercial speech nor is in public discourse. It's how it's used. The First Amendment protects communicative acts, not specific things. And so you always have to characterize the act in which the information is being used. That's the relevant First Amendment category. But to say information qua information is the First Amendment is speech, you're going to run into huge problems with data privacy. And I just very much doubt that the court wants to say HIPAA is unconstitutional and the regulation of FERPA and the regulation of educational information is unconstitutional. That is going to put it way out of line with public opinion and with the movement of modernity and the rest of the world. So it's rather how the information is being used and the reasons for it that are more going to be constitutionally at issue, and that will apply to social media like it'll apply to every other business.
Yeah, I completely agree, like 100% with that. I think Sorrell at the time it was decided was amazing because Kennedy had very broad language, but it certainly, for all the reasons you suggest, and then also as in terms of how the lower courts have read it, it doesn't apply that broadly. But Sorrell does say that if you're going to, the one area where it does give me pause when it comes to, say, social media is, Sorrell does suggest if you're going to restrict the sale or transmission of data for a kind of speech-related purpose, because you're worried about certain kinds of speech, it's not obvious to me how it applies in cases where, say, the government wants to regulate the ability of social media companies to sell data to advertisers so that they can target their advertising to consumers. Now we're getting much closer to the situation in Sorrell where the government is restricting but again, I completely agree that this is a tiny percentage of the huge universe of data privacy cases. I think the court is not going to strike down, and data privacy laws in general are not imperiled by the First Amendment, at least right now. Who knows what happens in 5 years? But there is this class of cases in which, say, the government wants to, as maybe it should, regulate how Facebook, say, what it can do when it's selling your data to a advertiser, so that they can target their advertising directly to you. Now I do think that we're much more in the land of Sorrell, and the First Amendment is suddenly in question. Now, again, if I were defending the law, I'd say so long as there's no viewpoint discrimination and it's about sort of making sure, I don't know, consumer privacy is protected, and it's no problem. But I could imagine litigation about that.
I think this is really an unpredictable area in so many ways. I think everybody here who speaks to anyone who's in their 20s knows there's just a completely, fundamentally, entirely different, how many more ways can I say it, new view of privacy, or perhaps we should say lack thereof. So that's out there. I think that's a big part of it. But also there's this idea of going back to some of our early talking about how it's regulated. Is there a command and control, or is it, if you're going to do this with it, you have to let people know you're doing it? So there's a lot of different areas, I think, just coming at it at the same time. And to state the obvious, the coronavirus and all of the privacy issues and the health issues that are coming up, some of that balance may start looking differently, I think, in ways that we would never have imagined before this, not in our lifetime. So,
And
another good example to think about that is these revenge porn laws, which are now in, I think, more than 40 states. And you'll see intuitions all over the map on that and the First Amendment.
so, and with that, I have to say, unfortunately, our conversation is over. It has been so wonderful to get to talk to you all. Please stay around for the rest of the day. We will have a set of really interesting panels, but really thinking through in some ways how the issues we talked about in this panel apply in disparate areas of law, including social media. So thank you all so much again for your brilliant thoughts. And hopefully I get to see you in person sometime soon.
thanks so much, Amanda. Thank you.
Yes, thank you. On behalf of the Abrams Institute and all of our attendees, you were terrific. Thank you so much. And we too hope to see you all in person coming soon. We're going to take a short break and come back at 10:45, please, for a session on regulating political advertising online. Hope to see you all then. Thank you.